Welcome back. This lecture sketches the structure of the American legal system as it relates to government surveillance. There are three topics that I'd like to tackle. First, the various sources of surveillance law that we'll encounter throughout the course. Second, the branches of the federal government and the role each plays in surveillance. Third, federalism, that is, the relationship between federal and state governments on surveillance issues. Let's begin with the sources of surveillance law. There's a common and understandable tendency to perceive law as monolithic, having one source and one definitive interpretation. In fact, law has many sources and is often subject to conflicting interpretations. Let's begin with some common sources of federal law, which we'll see throughout the course. An easy analytical model is to think of law as a set of layers. At the base is the United States Constitution, which delineates the structure of government and some fundamental rights. We will be talking extensively about the Fourth Amendment in this course, which provides certain privacy guarantees. We will also touch upon the Fifth Amendment, which prohibits compelled, self-incriminating testimony. Next up are statutes, enacted by Congress and the President pursuant to their constitutional powers. In this course, we'll explore several statutory schemes. One is the Electronic Communications Privacy Act, or ECPA, which establishes surveillance procedures for law enforcement. Another is the Foreign Intelligence Surveillance Act, or FISA, which loosely parallels ECPA for national security matters. Finally, a statute can delegate some legislative responsibility to an administrative body. That body then produces rules, which also have the force of law. Under the Rules Enabling Act, for example, the judiciary can promulgate procedural court rules. We'll spend a little time with the Federal Rules of Criminal Procedure, which govern grand jury subpoenas and warrants. We'll also look at the Communications Assistance to Law Enforcement Act, or CALEA, which grants some surveillance-related powers to the Federal Communications Commission. I'd like to make a few generalized observations about these three layers of American law. First, moving up the layers, law tends to be more specific. The security and privacy guarantees of the Constitution speak in broad generalities. Statutes and rules, by contrast, can be extraordinarily precise. Second, again moving up the layers, law tends to evolve faster. Interpretations of the Constitution change slowly. Statutes and rules, by contrast, can shift quite quickly. The final observation I would make is that moving upward in the layers, law is generally more protective of security and privacy. Some parts of the ECPA statutory scheme, for example, were originally intended to provide greater safeguards than the Fourth Amendment. In fact, a layer has to be at least as protective as the layers below it. If a surveillance power granted by statute or rule violates the Constitution, then it cannot be enforced. That's certainly not a hypothetical. We will see how some courts have found parts of ECPA and FISA to be inconsistent with the Fourth Amendment. So, there's a layered model of the main sources of surveillance law. That concludes what I wanted to say on the subject, so now let's turn to the branches of the federal government and how they relate to surveillance. The legislative branch consists of the Congress, that is, the House of Representatives and the Senate. At a very high level, those bodies have two roles in government surveillance. First, they enact statutes. Those statutes can provide or take away surveillance powers, and they can provide or take away security and privacy rights. Second, each House of Congress can act in an oversight capacity. Committees can hold hearings, for example, and demand records for their review. In an exercise of softer power, individual legislators can write nasty letters and can use the media to call attention to particular practices. So, there's the legislative branch. The executive branch, headed by the President, undoubtedly has the broadest set of surveillance responsibilities. We'll spend much of the course discussing law enforcement, that is, when the government investigates and litigates violations of the law. More specifically, we're going to focus on criminal law enforcement. You should be aware that there are civil forms of law enforcement, including many types of business regulation, and the applicable surveillance law is largely the same. The executive branch is also, of course, responsible for intelligence activities. We're going to discuss the National Security Agency's spying programs at some length later in the course. Some other areas of executive power that arise in surveillance law are the conduct of foreign relations and commanding the armed forces. We'll also touch on those later. As we discussed just a minute ago, the executive branch can be empowered to make rules, and those can relate to surveillance. Also, the president has a powerful voice in the legislative process and maintains a veto over statutory enactments. Finally, the executive branch has its own internal oversight mechanisms, including inspectors general in many agencies. A recently reinvigorated Privacy and Civil Liberties Oversight Board, or PCLOB, also contributes to executive oversight. The third branch consists of the federal judiciary. In the course of adjudicating disputes, federal judges have to interpret the law, including statutes and the Constitution. As we'll soon see, legal interpretation can be much more of an art than a science. Courts also engage in factual review. Many areas of surveillance law require a degree of proof before the executive branch can start snooping. The reason for using a separate branch for legal and factual determinations is straightforward. The executive has entirely understandable incentives to pursue vigorous law enforcement and intelligence. An independent branch that doesn't report to the executive is much more impartial. That's the theory, anyways. The judiciary can also act in a more general oversight capacity. Judges can and have been outspoken on surveillance issues, including in the media. Finally, the judiciary also has some rulemaking power. We'll soon look at the federal rules of criminal procedure. In the conventional teaching of American government, there are three branches, those that we just discussed. Let me add a quick note on independent agencies, which are sometimes dubbed the de facto fourth branch of federal government. An agency is independent in the legal sense if the president cannot arbitrarily fire the agency's head. The Federal Communications Commission, for example, is an independent agency. Under the Communications Act, its commissioners can only be removed for cause. The PCLOB, by contrast, is not an independent agency because the president can simply sack its members at any time. In theory, providing independence isolates an agency from political pressures. Emphasis on in theory. Keep that in mind, especially when we deal with the FCC. That wraps what I wanted to cover on the branches of federal government. So let's turn to the final topic of the lecture, how federal and state law interacts on surveillance. All of the material thus far has related to the federal government. There are 50 states in the Union, of course, and each has an opportunity to enact its own surveillance law. The basic structure is much the same. Each state has its own constitution, statutes, and rules. Federal surveillance law is binding on the states, but state law is not binding on the federal government. Let me give a concrete example. Suppose a law enforcement officer is investigating a California resident and wants to pull that person's recent phone records. Under the California Constitution, as interpreted by the California Supreme Court, a court order is required. So, if that officer is state or local police, they need to talk to a judge first. Under the United States Constitution, however, the Supreme Court has said that no court order is required. If the officer is federal, such as an FBI special agent, then they can use a judge-free investigative tool. So, there's a simple example of how state law can be more protective than federal law. The branches of state government closely match the branches of the federal government. Each state has a legislative branch, and all the states have 2 houses in their legislature, except Nebraska. Go figure. The executive branch is also similar, with a governor instead of a president. There is one key distinction I want to highlight, since it comes up often in surveillance issues. The chief state and county law enforcement officers are usually independently elected. Those positions are, respectively, the state attorney general and the district attorneys. In the federal system, by contrast, the attorney general is a subordinate of the president, and the United States attorney in each judicial district is a subordinate of the attorney general. The practical difference of electing prosecutors can be substantial. State and local law enforcement officials can exercise a tremendous influence on politics and litigation decisions. Finally, every state has an independent judiciary. The one distinction that I'd like to emphasize here is that in many states, judges are elected. In the federal system, judges hold lifetime appointments. State judges are undoubtedly subject to different pressures by virtue of directly participating in the political process. Alright, that's it for the gory details of government structure. In the next lecture, we're going to discuss a topic that may be a little less familiar: the steps of American legal proceedings.